So moving forward, I'd love to introduce to you our mentors for today. Okay. So Mrs. Natalia Odidika is the Esezibor. Sorry if I could not pronounce your name well. Um, so Mrs. Natalia Odidike Ezebo is an accomplished legal practitioner, accredited mediator, speaker, trainer, and author of the book 7 Easy Steps to Handle Depression that many don't know. She is the founder of the principal partner at Nativity Attorneys, a legal practice that specializes in mediation and advocacy services. Ms. Natalia is also the creator and host of a weekly live program on Facebook called Legal Moments with Nat, where she offers free legal guidance to participants. Natalia is highly regarded for her expertise in dispute resolution and is a mentor to mediators undergoing mentorship programs at Lagos Multi-Door Courthouse. She also guides this. She also guides law students from various universities across Africa, Asia, Europe. Natalia has served as an expert assessor and judge in numerous virtual mediation and negotiation competitions, both locally and internationally. She has several local and international certifications that back her extensive experience in dispute resolution. Natalia is an active member of several prestigious professional organizations, including the Nigerian Bar Association (NBA), the NBA section on business law, the Employment and Labor Lawyers Association of Nigeria, and the National Association of Catholic Lawyers, Lagos Archdiocese. She currently serves as the Assistant Secretary for the Employment, Labor and Industrial Relations Committee of the NBA section on business law and its committee members of the NBA Lagos branch continuous legal education. Natalia is also a member of the recruitment committee of the Employment and Labor Lawyers Association of Nigeria and a trained mediator on the panel of neutrals of organizations such as the Lagos Multi-Door Courthouse and the Nigerian Chambers of Commerce Dispute Resolution Center. In addition to her legal practices, Natalia is passionate about peace and advocacy and has been appointed as a South Seoul HWPL Peace Educator Ambassador within the African region. Natalia is fluent in multiple languages, including Igbo, English, and Yoruba, and has a basic understanding of Hausa and Sign Language. Besides her professional endeavor, she has diverse interests, including speaking engagements, training, facilitation, coaching, traveling, moderating events, running marathons, singing, playing football. So we'll move forward to our second mentor for today, Mr. Samuel Arobosa Osarene. Samuel is a mediator. Sorry. Samuel is a mediator, an arbitrator, a peace advocate, a negotiator, and a distinguished ideal practitioner to the core. He possesses advanced knowledge and understanding in peace and conflict advocacy, community mediation, family mediation, workplace conflict, management and resolution, peace building, among others. He is a minister of God. He holds a PGD in theology from the Redeemed Christian Bible College, a graduate of the Word of Faith Bible Institute in the Living Faith Church, a lover of peace and the youth. Ren is a graduate of Banking and Finance from the University of Benin. He has a passion for advancing the gospel of ABR, which accounted for his willingness to volunteer and facilitate various means of peaceful and amicable dispute resolution. He is the principal consultant of Facet Curry, an associate consultant, and the founder of Rehoboth Encounter Prayer Group. He is a certified peace and security consultant, a chartered human resource consultant, a fellow of the Institute of Chartered Mediators and Facilitators, a member and a resolution specialist of the Institute of Chartered Mediators and Conciliators, ODR panel of neutrals. He's a member of Nigerian Institute of Chartered Arbitrators. He's a faculty member of Settlement House ADR Training Institute and Nigerian Institute of Chartered Arbitrators. He's a fellow Chartered Institute of Human Resource Management, amongst others. So we'll move forward to the third mentor for today. So Mrs. Baratu Johanna Dangona. Sorry if I'm missaying your names. Pardon me for that. Mrs. Baratu is passionate about dispute resolution as well as core legal practice. Her desire to see that disputes are resolved amicably in our society prepared her to enroll and become a certified mediator and arbitrator. She is a full member of Settlement House ADR Training Institute, an institution for training, practice, and certification in ADR. She's also a full member of the Nigerian Institute of Chartered Arbitrators, an institution that trains and certifies arbitrators and mediators in Nigeria, and holds a master's degree in law. She was called to the Nigerian Bar in 2007 and currently a senior associate at JB Dauda Stan and Co. Kaduna, Nigeria. She has expertise in labor-related matters and has successfully published articles such as Character Evidence in Criminal Case and the role of the National Industrial Court of Nigeria in resolution of labor disputed in Nigeria. So we'll move forward to the first mentor for today. Mr. Nachang Nangwang. Mr. Nachang is a lawyer and the principal partner of the law firm N. Nachang and Co., a law firm based in Kaduna, Nigeria. He is a certified teacher, trainer, and facilitator. He is a faculty member and the executive director of Settlement House ADR Training Institute, an institution for the training, certification, and practice of alternate dispute resolution. He is also a member as well as a faculty member of the Nigerian Institute of Chartered Arbitrators, a model arbitrator certification institution in Nigeria. He is a certified dispute resolution specialist in international mediation campus, trained mediator and attorney mediator, a certified mediator advocate, an arbitrator, a certified negotiator, an ADR practitioner, a restorative justice practitioner. Oh, sorry for my audio not being clear. Can you hear me now?
Yes, I can
Hello?
hear you.
Okay, sorry
But it was
for
cracking
that. Okay, so sorry. Okay, so Mr. Nat Chang is a certified conflict manager, a certified ADR registrar secretary, a holder of the Mediator Academy, United Kingdom certificate in commercial mediation, accredited by Institute of Chartered Arbitrators UK, a medical law enthusiast, and employment and labor law expert, amongst many others. So, I think we'll move over to the fifth mentor for today. Okay. Sorry, please, the slide for the fifth mentor. Okay, we'll just dive in to the next section, which will be the presentation by the mentees. So our mentees ready for their presentation.
Yes, we are ready, ma.
Okay. So I'll leave the floor for you guys.
First time in my life.
Okay, good evening, everyone. Can you all hear me?
Yes, please. I can hear
Yes,
you.
I can hear you.
Yes, sorry. I want to firstly sincerely apologize for not being able to share the last mentors flyer. And please, I would like to ask the group presenter, please, to come up and quickly make the presentation so that we can go on with class. So please, group presenter, please do sharply make your presentation so that we can continue the rest of the class. Thank you. Okay, sorry, is our group presenter not ready? Group one presenter, please, can you just kindly come up and make your presentation? Okay, if group one is not ready, can we have group two? Ms. Ogochukwu, please, are you the one to make presentation for group one?
Yes, I'm reading.
Sorry, we can't hear you.
Good evening. Hello.
Yes, good evening. We can hear you now. Good evening.
Okay, so I'm Emefa Tamaklo and I'll be presenting on behalf of Group 2. So my first topic is draft terms of settlement. Hello.
Yes, please, can you also try and share your screen?
No, please, I'm presenting for Group 2. Please, should I go ahead and share and present for Group 2?
Yes, please go ahead. But please, we also like to have your presentation with your screen shared so that we can see your presentation on.
Yeah,
on
please,
the.
someone will be doing that. So.
All right.
Okay, so I'm going to be discussing on drafting terms for settlement. So when parties involved in a legal dispute finally come to a conclusion or a settlement, the first step to take is to ensure that the parties agree on the terms of the settlement. So the mutual agreement ensures that both parties are clear on their obligations and responsibilities. And secondly, it's advisable to ensure that the settlement is in a written form so as to prevent future misunderstandings on the terms. So once the parties agree, once there's a meeting of minds of the parties, it's advisable to write it, and then the parties should sign the written agreement to confirm their acceptance of the terms. So once the parties agree, if they want to show their consent, it would be better it's in the form of a signature so that in case of any future misunderstandings, they can easily refer to the record and see that, oh yes, I agreed that, oh, I'll take maybe 50% of the house or something. So the signature is very important and it should be done in the presence of a witness. So basically that is how to draft the terms of a settlement. And the relevance of drafting the term is to prevent any future misunderstandings, because in the settlement we have all the responsibilities and obligations. So if someone does not understand or something, we just refer to it. So refer to the record, then they're able to. And then the next thing is to discuss and draft an agreement to mediate. So an agreement to mediate is basically a voluntary consent to the terms of settlement. So an agreement to mediate signifies the voluntary consent of parties to engage in the mediation process when disputes arise. So one thing about ADR is it ensures flexibility, and you are able to choose your mediator. And you're able to choose whether you want to go for mediation or you want to go for litigation. So it's not forced on you. So agreement to mediate basically means that, oh, I agree that I don't want my case to go to court, but I want to use an ADR method like mediation. And the agreements will come in the form of, let's say, it's a document. So maybe something like I, MFA Tamaklo, and then they'll mention the other party's name, agree that so and so should be my mediator. And then it will stipulate the role of the mediator, that the mediator should be impartial, and yes, basically that is it. And then yes, so the mediator should be impartial and should guide discussion towards a resolution. There should be transparency, honesty, and all parties are required to disclose relevant information. So that will be stated in the agreement to mediate, the document that shows that you've agreed that you want to submit your case for mediation instead of litigation. And the next thing I'll be discussing is discuss how to resolve deadlock in mediation. So it's important to, okay. So the first step to take in resolving deadlock in mediation is, first and foremost, you have to maintain open communication. Clear and open communication is essential in overcoming deadlock, so as to encourage all parties to express their opinion and their concerns and interests. So this is quite better than litigation. So for this process, it ensures confidentiality, flexibility. You are able to say what you want, and yeah, that. And it's important to identify, to brainstorm creative solutions in order to resolve the deadlock. So it's the process encourages parties to think outside the box and come up with innovative ideas that address their interests or whatever concerns they have. And then we also have to consider third-party perspective. So it will be important that the mediator also comes and says that, oh, I feel it should this is how we should resolve this, or this is what should be done. It's not forced on you, but it's just an opinion that the mediator can also bring in. And then taking breaks and regrouping when necessary. Deadlocks can be emotionally taxing. So if tensions escalate or discussions reach an immense, parties to cool down, and that is a very good way to solve the rise during the mediation process. And then it's also important to explore alternatives to
Sorry, please, is it only me that can't hear the group presenter?
It seems as if I can't hear her too.
Okay, please, our group presenter, please, if you are with us, please, you can continue with your presentation. Can you hear us? Okay. It seems she's having a little issue with her network. All right, please, we'll just go ahead and have group one, since she will not be able to continue with the presentation. Please, can we have group one presentation?
Yes, sir.
Yes, please go ahead and make your presentation. Please, presentation time is 7 minutes. As best as you can, please try and stick to time. Thank you.
Thank you, sir. Okay, starting with mediation. My name is Ogochukwu Concepta. Okay, what is mediation? Mediation is a structured interactive process which an impartial third party called mediator neutrally assist. Normally, from what we discussed last week, mediation, we have to have a third party, an impartial third party that is trying to mediate on behalf of disputing parties. This impartial third party is a person that is specialized in this particular type of communication, that you'll be able to communicate and then be able to identify the problem of the disputing parties. What are the career opportunities in mediation? A mediator finds employment in the following areas. Number one, the human resource in corporate sectors. Human resource most times are organizations that they are actually major in maybe employing students, employing employees, or doing so many things. So a mediator is needed in this kind of aspect because they'll be required to use their expertise. Maybe when there is a dispute or something, they can be able to resolve it. And another thing is also in legal firms. Legal firms, there's some situations that might come up in a law firm that might not really need to go to court. So in this case, a mediator will come in and just settle them, most especially maybe marriage or so many things that are disputable under mediation. The mediator can come in and be able to settle such issue. Even sometimes in court, the court can make a judge can make referral to a particular case and refer them to to a mediator that will be able to settle that particular dispute. Another place that a mediator is needed also is in education as a trainer. A mediator can come into education, he can train people just like we are doing now in JIIPCC, PPC. So they can come in and train people that can become
Please, Ms. Ogochukwu, please, can you hear us?
official mediators, people that have the zeal, that want to be able to have.
Okay, it seems our first presenter is also having network issue. I sincerely apologize for the network itself. It seems today I don't know, but irrespective, we'll still be carrying on with the session. Good evening once again. I'll be taking over from the previous moderator. She had to leave. Her phone was about to shut down. So welcome to today's session. Our topic for today is mediation and career opportunities. I want to thank all our mentors that are currently here with us on call. Thank you for joining. Thank you to also our mentees that are able to join in for today's session. Right, I want to say a big thank you. You're welcome to today's session. I want to say thank you to the group presenters that put in their effort to make sure that they tried their possible best to present. We would like, in view of future classes, we would like to also add that sharing of screens during presentation are very core and essential. and that if the group presenter is unable to share their screen, members of the group can volunteer to help share screen. So moving forward, we ask that presenters and also the members of the group should prepare ahead of time to help the presenter share screen in a case where the group presenter is unable to share their screen. I want to apologize to Miss Eunice Olatunji from Olatunji. Yes, sorry for not sharing your screen, ma. For not sharing your profile, rather, ma. You are also welcome to today's session. I would like to just keep the floor. We'll be going shortly into our mentors parts for today's session. But before we do that, I would just like for us to quickly turn on our cameras before the weather and the place becomes very dark for us to be able to take pictures. So please, I would like to ask for us to turn on our videos so that we can take a quick picture and then continue with the class. Please, can we have mentees turn on their videos, and if possible, also our mentors. Please. Okay, thank you very much. We've been able to take our picture. Thank you so much for complying. And if it's possible, I also like to ask our mentees to keep their videos on so that we can know and also see your face as the session continues. I would like to have, okay, we are going into our mentors session. We would like to hear from our mentors on today's topic. We would like to hear them introduce the topic to us, mediation and career opportunities. We would like to have firstly Mr. Yan Chang. Mr. Yan Chang, the Executive Director of Settlement House ADR Training Institute. Sir, please, if you're with us, you can come join us, sir. Thank you. Mr. Yan Chang. Okay. Seems Mr. Yan Chang is not currently with us. So please, we'd like to have Mr. Samuel. Mr. Samuel, please, can we have an overview of today's topic from you? What is mediation, sir, and what are some of the career opportunities that are available in mediation? You're welcome, sir.
Thank you so much, Mr. Dennis. Please confirm if you can hear me loud and clear.
Yes, sir, we can hear you.
Okay. I will confirm that Mr. Nathan is not on the call.
Yes, he's currently not in the call.
Okay, no problem. Thank you so much. I want to begin by appreciating the groups that have made their presentations. Thank you so much to Group 1. Thank you to Group 2 for being able to capture your thoughts into the presentations we've had. I'm sure if given more time, you will be able to make a better presentation. I want to also appreciate other mentors for joining us in this evening session. You are remarkable and we appreciate you. If you don't mind, just trying to harp on the presentation so far, the presenter for Group 1, I noticed you were not too relaxed when making your presentation. We want to make an appeal that you just be at your best and make sure you have a good frame of mind when making your presentation. Now, over to the question that I was asked. If you got it right, Dennis, you want me to throw more light into what mediation stands for, the career opportunities in mediation, right? Please confirm.
Yes, sir.
Now, before I go out, there was a way Mr. Nachang helped us structure the presentation of mentors last week. I don't know how many mentors we have on the call that we can quickly agree on which of the sections we will take in order not to have a repetition from each other.
Okay, I think Mr. Nyacham is with us. Sir, please, can you confirm you're with us, sir?
Mr. Samuel, your voice is cracking.
Mr. Nachang, you're welcome. We're glad to have you, sir.
I've been trying to speak. I don't know why you were not hearing me.
Okay. So over to you, sir, to help us structure
Go ahead, sir.
The mentor section, sir. I was making a reference to the scenario we had last week where you had to call on each mentor to take a portion of the entire scope. So it will help us into this section to where maybe you call out a mentor and give the mentor a specific assignment or task to throw more light into pressing issues in order for us not to have overlapping emphasis on a single issue. So over to you, sir, to help us structure that sector. Thank you.
Mr. Samuel, your voice was really cracking.
Okay, Mr. Samuel was saying that during the last session, you gave the mentors a structure for the topics or the aspects that they were to handle. He was asking if that can be repeated so that there's no overlapping of ideas and discourse from our mentors.
Okay, Mr. Samuel, can you hear me?
Loud and clear, sir, I can hear you.
Okay, thank you very much. Dennis, thank you very much for that wonderful work. Thank you to all our mentors for tuning in. You are all welcome. I think one thing that we need to do as fast as possible is, we said we've not introduced one of our mentors. She's joining us all the way from the United Kingdom. So, Dennis, permit me, if you do not have her profile, so that I can introduce her a bit. Is that okay?
Yes, sir, that's okay, sir.
Mr. Dennis, can you hear me?
Yes, sir, I can hear you, sir. I said it's okay, sir. You can go ahead, sir.
Okay. So, Michelle.
Okay, sorry, it seems Mr. Nyacham is having a little bit of network issues. All right, please, Miss Eunice may have to leave us very soon. So, but before she leaves, I would just like to welcome her to come help us before Mr. Nyacham joins in, to just help us, give us a brief from this perspective, from her own perspective, maybe just a brief on what mediation is and the career opportunities in it, ma.
All right.
Okay, so,
Yeah.
sorry, Dennis. Dennis, can you hear me?
Yes, sir, we can hear you, sir.
There seems to be a kind of network issue here. And
Okay, I don't know what's the problem with Mr. Nyancham's network, but Miss Eunice, ma, you can go ahead.
All right. Thank you, Mr. Dennis, and thank you, JIIPCC and Shati Home for this initiative. And I want to thank all my fellow mentors that are here, as well as the mentees, because it takes courage to be here. That shows your commitment to continue education and learning and a growth mindset that you have. And I want to commend everyone who had presented today, because it is not easy. I'm a lawyer by training, going to like almost 2 decades. And each time I still have a case, I still have to prepare as if I don't know what I'm doing, read and read and read and read again. Even in presenting, I'll have to go over my slide and over and again. So it is not easy. And for you to put yourself forward to do presentation today, kudos to you. That's very nice. And I know that you will still make better presentation going forward, because what they say, practice makes perfection. All right, thank you very much. I know we all know what mediation is, because from your slide, there is a definition of what mediation is. It's a facilitated negotiation done by a neutral party called a mediator to help party collaborate or cooperate towards arriving at a settlement that they can live with. A mediator is not there to give opinion or to advise that do this or to apportion blame on parties, but it's to help parties direct focus on the issue at hand and see how they can collectively resolve the issue if possible. And if you find yourself in this industry, then you find yourself, you can say that you're very lucky, because you are affecting lives. Anywhere you have human being, there is conflict. Conflict with oneself, conflict with other people. So you can see that the sky is not even a limit as a mediator. If people do not have conflict with other people, you may have conflict with oneself, which shows that as a trained mediator, you can actually be a conflict coach for individual. Conflict arises when there is a conflict or contradiction in values. As we continue to grow up, there are some beliefs that we have in the past, and because of the education we now have or information we now have, we continue to conflict within ourselves and sometimes second guess ourselves. As a mediator, you listen. So sometimes our work is even can be likened to the work of a therapist, a work of a counselor. But when you have a mediation, the kind that the Hammer defined for us, you are not working as a counselor and you're not working as a therapist. You are there to listen to party and play a neutral role. There are many debates about whether a mediator can remain neutral throughout the process. But we make efforts as far as possible to remain impartial while you are trying to help people mediate. And I can mention, because we have so many opportunities, there are people everywhere. Anywhere you find people, there is an opportunity for a mediator. Like the presenter presented in HR, as HR person, as customer service agent or advisor, consultant, we are all there. Mediation gives you a very wide soft skill that everyone needs to survive in any endeavor you are embarking on. As a mediator, you're a good communicator. You know how to get the attention of the party. You know how to bring people down from their high horse and get them to reason and see from another person's perspective. So there are a lot of opportunity for us, which I know that many of us, many mediators, mentors we're talking about today. I would not want to take much of our time, because I think all the mediators have 10 minutes to talk, as in all of us collectively have 10 minutes to talk. So I won't want to take much of our time. But based on the, if I can give a feedback on the slide that was sent to us, like I mentioned, we have tried and we all learning and we are all working. I mean, a work in progress. We are working towards perfection. This slide, I think it was too wordy. If you're going to be making a presentation, it's better you just put the point and you can use a picture to demonstrate what you have. Otherwise, you will lose your audience because they will now be focused on the text that you have on the slide. So when you are making a slide presentation, try to make it as scanty as possible. Just put the key points, then you speak to it because we are not doing public reading. What we're going to be doing is public speaking to the slide that you have presented. Then I noticed also on the agreement to mediate, just 3 paragraphs. In your agreement to mediate, you may do well to include some of the principles of mediation. And the key one that I think was missing is confidentiality agreement. It is important that we state that in the mediation, agreement to mediate, for parties to know that this is a voluntary process. This process is confidential. And the only thing you can take out of this process is the terms of settlement if parties are able to settle. So that when you have that at the back of the mind, you know that it's only the people that signed the agreement to mediate that can be in the mediation room. Anybody else who wants to be in that session has to sign the agreement to be bound by that confidentiality agreement. We've seen situations where people are trying to resolve, to even get that, you have to be vulnerable. When you get people to trust you as a mediator, they become vulnerable with you. They become vulnerable in the meeting. Some people break down and cry, and should be disastrous when you have an observer recording the section. And perhaps maybe people were not able to settle and the video go viral. What would be the remedy for the other party? So as a mediator, I think it's important that we take that we take note of that and include it in our agreement to mediate. Also, I noticed that the terms of settlement, maybe it was a lawyer that drafted it. As much as possible, we try to avoid, let's try to make things simple. Not hearing hereafter and wearing that a layman will not understand. Make it as simple as possible. And your agreements or terms of settlement need to be specific, need to be measurable. I don't know if we are the one that presented, that prepared that terms of settlement, if any of the group was the one that did the terms of settlement. I noticed that, yeah. Sorry, is everybody listening, hearing me? Hope I'm not talking to myself.
Yes, ma'am, we can hear
you. Yeah, with you.
All right, thank you very much. The consideration paragraph or clause was so jam-packed that even sometimes may become confusing. So it's important that we break it down. Let each terms of agreement be in different paragraphs, and the payment of money, how, when, to whom. So you may do well to state the accounts that the money will be paid to. How will it be paid? When will it be paid? I saw that was not in the agreement, and that may actually cause another potential conflict for parties. So as a mediator, we need to be specific to ensure that another conflict does not arise out of what we've said that we have helped parties to settle. I think at this point, I want to stop so that other people can speak to it. Thank you so much. I'm so sorry I may not be able to wait till the end of the program because of another engagement. Thank you for having me once again.
Yeah, thank you so much, Miss.
Thank you, Eunice. Thank you very much for creating time out of your busy schedule to be with us this afternoon. It is a privilege that we do not take lightly. We're very sorry for not introducing you earlier. And before you go, please, our mentees, this is one of one lawyer that has passion for mediation that we can learn from. So please do well to connect with her on LinkedIn. She's presently in the United Kingdom, and She's a legal practitioner. She has relocated from Lagos to United Kingdom. She is a mentor, and she has been a mediator for the Lagos Multi-Door Courthouse, which happens to be one of the first court-connected ADR center in Africa. You know, she has mentored a lot of people in a lot of students and ADR enthusiasts alike. She's a notary public of Nigeria, and she belongs to many professional bodies, you know, and she has a degree. She has been practicing for quite a while now, and we are really happy to have her on this program. So please feel free to reach out to her when you have any question. Connect with her on social media handles. I know that she has quite a number of resources. She's going to be coming back again, you know, in the course of time, but please feel free to reach out to her. So thank you very much, Eunice, for your contribution. Sorry for keeping you this late. You can go for your engagement, then we continue from there.
Thank you.
Thank you. Dennis, thank you for what you are doing, for the good works. Okay, she has shared her LinkedIn profile for us to make use to connect with her. Please feel free to do so. So having said so, we're talking about mediation and career opportunities in mediation. Like Eunice have said, and you know, we are living in a world where we have a lot of issues, a lot of problems. People are looking for solution for their problems, and most times they want to go to the police, they want to go to court to ventilate their grievance. They don't want to take the laws into their hands. And we are trying to tell the world, and we are trying to tell the people, and we are trying to also groom you as mentees to get to know that mediation is one of the ways in which you can settle your dispute, and not just settle your dispute, but you can do it amicably. And you know, mediation affords you that opportunity to get involved in your dispute. Unlike the court system where somebody will just be there, and then after listening to you, he will say, "This is my judgment." Mediation affords you the opportunity to be able to be involved, actively involved in the resolution of your own dispute or your own problem or your own issues. So you can see that your opinion matters. You are the one that will choose who is going to be the mediator. You are the one that is going to choose the venue. You are going to choose the time frame. You are going to choose the solution. The mediator is there to help you generate several options for settlement, and he's supposed to be impartial. He will stay in the middle. By virtue of his training, he will be able to give you a lot of opportunity to do a lot of things. You know, he will help you understand the perspective of the other party. He will help you also understand the main issues. He will help you streamline the important issues that need to be discussed. You know, these are some of the things that you benefit from mediation. So mediation has a lot of things then that we're going to be looking at shortly. So we have all our mentors in the house. Natalia, are you here?
Yes, I am. Good evening.
Okay, is Mrs. Favor around?
Yes, Mrs. Favor is here.
Okay, can you say something? Let me see where you are.
Okay, good evening, everyone. Good evening, sir. My name is Favor Emetanjo. I'm a certified mediator with the Lagos Multi-Door Courthouse. I'm an author, I'm a counselor, of other things. And I've been so impressed with the presentations thus far. And I hope to be part of this group to learn and to share from my own experiences as well. Thank you very much.
Thank you very much, Mrs. Favor. Ms. Favor is one of the ADR practitioners, and she has volunteered to be available to contribute. And we pray that we will all tap from her wealth of knowledge and experience. Thank you very much for joining us. We are happy to have you. So having said so, Natalia, you are here. We're talking about mediation. We're looking at career opportunities in mediation. You have listened to the presentation made by the parties. Do you have some comments? Do you have areas that you want to specifically pick out and speak to it? Please, if you do, go ahead.
Okay, good evening, everyone. So,
good evening.
Okay, I just want to confirm that you can hear me. So I want to, talk about the aspects of, career opportunities in mediation, right? So I looked at the presentation, which is lovely and very commendable. So I see that there are opportunities for, mediators in various organizations, even government and all of that. But let's say you don't find a job in a government establishment or in a bank or in HR. What do you do as a trained mediator, and you want to remain relevant and also, earn from it? So as a mediator, you have skills already. Now, if you're not earning money as a mediator, which is one of the ways, right? If you find no one to bring matters to you for you to resolve and get paid for it, you can make money by being a mediation advocate. So some persons are trained as mediation advocates before they became a mediator, while others simply focus on being advocates. So who are advocates? When you hear the word advocate, the first thing that comes to your mind is, oh, a lawyer. But no, that's not what it means. The advocate's position is not reserved only for lawyers. You have non-lawyers who are also advocates, who are trained in that capacity. Now, the good thing is that we have one of us in here who is a mediator, who is not a lawyer, but she's a mediator. She's been practicing for years. She has a wealth of experiences in different areas. So that's to tell you that being a mediation advocate, you are not is only restricted to being to only lawyers. So as a trained mediator, as a mediation advocate, you can actually earn your money. And as an advocate, what do? You represent your party in mediation sessions, and so you can get your money, discuss with the party you're representing, and get paid for it. The good thing is that in some cases, even though people prepare documents that they have to exchange during the session, you can come to mediation session without even your lawyer drafting any document on your behalf. I've seen that in my course of practice, where some persons come, okay, we haven't heard, where's your own response? They said, we don't have, we're here to discuss. And the most important thing is that they are present there and you are having that opportunity to discuss with them. Because what if they come with their presentation or their documents and they're not speaking at all? Another opportunity for you as a person you can make money from mediation in a career path is becoming a trainer. I'm sure you have attended a lot of events or webinars where they are told you about being, being a trainer. That's one way you can actually make money from mediation. So if you're a trainer, you can get money. If you're a facilitator, whichever the case may be. And there's this aspect of being a researcher. I remember when I was a law student, was it law student or I was just called to the bar? Yes. So at that point in time, I went to court with my principal who attended a mediation session. And I noticed that there were 3 people, or even, I think it was an arbitration session, yes. So there were 3 of them. There was the arbitrators, and then you had the secretary who was taking that note. So people are training for that. You can become an ADR, researcher, a secretary, and make money from it, either you're sitting in a mediation session or as an arbitrator. There are many opportunities in that regard. So depending, as a professional, negotiator, you can make money from it. People get paid. People they are trained to just negotiate on behalf of people. So they charge their money. So, and as a mediator, you are a negotiator. So there are some people who are very good at that, in that regard. They're very good at that. And there's another opportunity for you to become a writer, you write, or even an expert witness, or your opinion is sought after. I remember a matrimonial matter I was handling sometime in August. It was a very toxic matter. So at that point, because a child was involved, and I didn't want to just go ahead without getting to the root of it. So we had to take a break to search for an expert in child-related, disputes between a married couple, because it was child custody. And the father wanted the girl, the mother insisted, no way, it's going to be me. So the situation was torn in between. And in that kind of situation, you will have to take the child to a foster home. So at that point, I requested for an expert in that field who had always given expert opinions in the area court. So they sought for her, we spoke, and that assisted me to carry on with my, my mediation session. Did they settle? No. It was a very toxic experience. They didn't settle, but at the end of the day, we made a headway about it. And then you could be, again, an ADR judge. As a mediator, you're appointed as a judge in the ADR session. That's an opportunity for you to actually make money. And then they are taught neutrals evaluator. They're ombudsman. Sometime about 2 years ago, I became, I was applied and I was taken by World Bank as one of their mediators. So I'm a mediator, in World Bank. And one of the roles we play is the role of the ombudsman, and it actually involves community and all of that. So there are so many opportunities by which you can, make money. I'm sorry, I think I'm receiving yes, I'm in a meeting. It doesn't come in. Okay, so I'm sorry about that. So so basically, there's so many career opportunities for you if you are going into mediation or other ADR, aspects of resolving disputes. Nanchang, I missed out on the other question you asked me. There's a question you asked apart from the career opportunities.
Yeah,
yes, I can see on the screen. What's the other question?
Yeah, I wanted to, you've shared your, I wanted you to just pick an aspect which you have done already. Pick an aspect of, from their presentation, and then make your input in respect of that. So you have looked at career opportunities, which I believe you have done justice to it. There are a lot of opportunities, as you can see on the screen. You can be a mediator, you can be an arbitrator, you can be a mediator practicing, you can be a mediation advocate or an advisor. A mediation advisor is one that is not a lawyer, but is trained to represent people in a mediation session. But when you are a lawyer already and then you are to represent people in a mediation session, they call you a mediation advocate. So if you are not a lawyer, you are called a mediation advisor. So you can be actually a conciliator, which now has been replaced, in the Arbitration and Mediation Act 2023. An ombudsman, in fact, you can be a human resource manager perfectly, because the skills you are learning are life skills, right? It helps you in your home, it helps you in your business, it helps you to relate with people, it helps you to prosper your business, it helps you to develop emotional intelligence, all manner of things. So you wonder why sometimes when you go to an organization, from the way and manner some of those people at the gate or at the reception treated you, you say, nothing is going to bring me back to this place again. If they have learned some of the skills we are learning under mediation or some of the trainings in ADR, they would develop the ability to be able to treat people well. So you can be a human resource manager, you know how to manage people, how to help them do certain things, you know, how to prevent conflict, how to manage conflict when they come, a lot of things like that. You can be an investigator because most times you are trained in the art of asking questions. You want to find out what happened. You learn about open questions. You learn about closed questions. You learn about questions that will narrow, you know, whatever you are looking for and all of those things. So these are things you can see. You can be a peace builder, a conflict manager. You can be a facilitator. What we are doing here is facilitation. You know, you can be a trainer. You can do a lot of things. You can go into consultations. You can train people. You can do seminars. You can do a lot of things actually. So these are some of the career opportunities that which we have already mentioned. So
Yes.
having said yes.
Yes, sorry. Thank you for listening. Like it's all encompassing. But when you get to the point, I want to talk about, you know, that breaking the deadlock. Maybe when we get there, I have a few things to say because I looked at the documents that the mentees shared, and I want to speak on some things that they, some other aspect that they left out. So if the time comes, you let me know. I could just speak to it as well.
Okay, thank you very much. Ms. Favor, I don't know if you are here with us. Will you like to shed a little light on the processes? The process of mediation, the processes, stages of mediation, you know, perhaps if you have already agreed that you're going to go into mediation, and then what are the processes? What are you supposed to do to be able to have a successful mediation session?
Okay, thank you very much. I'll just add to what Eunice had said, the other presenters and Natalia. You know, one of the major things you need to get to be a good mediator is to have very good listening skills. You must be able to listen, you know, listen to the parties, listen to the advocates, listen to the counsels, if they are counselors. Then the process of mediation, first now, we used to say you could just get into mediation without having an idea. No, you have an idea of what you're going to be discussing, what the case is about. You can go an extra mile by trying to get this information before your date for mediation, so you know what the dispute is all about. So you have that, and then you start the mediation by the introduction, talking about yourself, introduce yourself, all the parties will introduce themselves. Then you talk about the process, you know, Eunice has talked about that confidentiality, you know, agreements to settlement, agreement to mediation. You talk about the terms of settlement, the TOS, you know, that will be binding on all the parties. After the terms are actually generated from the discussions that all the parties and everybody that is present at the mediation center brings on the table. And that's why we say that mediation is a win-win situation. So both parties are bringing, no, I'm going to pay you 1,000 naira per month for my apartment. You say, naira. So you can negotiate. You have the power to bring on the table what would be favorable to you as one of the disputants. That's the beauty of it. And then you now begin to talk about you have to talk about respect during the session, and then, like I said, talk about the terms of settlement, which will be binding on everybody. That would be in addition to what the other speakers had already indicated. Thank you. Are we together?
Yes. Thank you very much for that wonderful contribution. So, Baratu, one of our mentor is here. Baratu, are you with us?
Please. Can you hear me?
Yes, ma, we can hear you, ma.
Okay, thank you.
Mr. Yacha,
We can hear you.
Thank you.
Hello, we can hear you.
Yes, I didn't get any question. Did you ask any question? I
Yes,
just heard.
you have listened to, you have the mentees presentation.
Yes.
Are there areas of interest to you that you want to comment on?
Yes, I just want to comment on some of the portions in the settlement agreement. I don't know whether that should be done at this stage or it could be done
Go
later.
ahead, please.
All right, so in terms of the charging of the fee for the mediator, there are some of the things that need to be put into consideration, whether the mediator is going to charge hourly or he's going to charge for the mediation session per day, which should be included in the settlement agreement, which should also be included in the agreement to mediate, so that it will avoid conflict at the end of the mediation session, whether the mediator's fee is already settled and how he should be paid is also should be settled. And another aspect I want us to touch light on is also the aspect of the fact that in charging for mediation, you also have to consider not just the fee of the mediator, but also the cost of the mediation, which should be factored into whatever will be the mediator's fee at the end of the day. So when we consider the fee of the mediator and also the fact that there is actually career opportunities as a mediator, it will help our mentees to know that mediation is actually something that they can vie into and something that they can confidently go, a career path they can confidently choose, and they are sure they will get something good out of it. That is in addition to all the other career opportunities that have been given by other mentors, and just a touchlight on what should be factored in to the fee of the mediator, either as an advocate or as an advisor or as the mediator himself. You have to know how to charge fee when you have the employment. Thank you.
Thank you. Thank you very much, Baratu, for that wonderful contribution. So we are looking at mediation and career opportunities in mediation. Some of our mentors have highlighted some of the important things that we need to know in mediation. And so now we are going to be looking at some other important and critical issues that we need to consider. I have not seen anybody make any comment on opening statement, like from the presentation of the parties. I've not seen somebody, they have not seen a comment on opening statement. You know, opening statement is one of the important things. If you come for a mediation session, aside from signing the agreement, your opening statement is one of the important things that you need to do, because that is what is going to inform the parties who have not attended the session before to know what actually brought them. Because if you just come and sit down and just continue talking, they will be like, what is this? Is it another court session, or maybe something I need to just come and do before I go to court, and all of those things? So the opening statement for a party is very, 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 very crucial. So a mediator must make his opening statement very clear, precise, highlighting very, very important issues and matters in the course of the mediation. So I will call on Mr. Samuel to shed more light on this aspect of opening statement and its significance. Very, very important.
Thank you so much, Mr. Nachang, for this privilege. I want to appreciate all our mentors that have taken out time to actually stick with us and provide clarity on issues. Now, talking about the opening statement, as we all know, the way you make your bed, so you will lie on it. Opening statement helps to chart the course for the entire section. You may be meeting with parties for the first time. You may have met them before.
Okay, so Mr. Samuel, as you are talking about the opening statement, you will highly discuss the principles, the cardinal and important principles of mediation. I know we have touched a little last week. So today, since we are dealing with mediation, please, you can be as fast as possible to discuss, to also touch on those principles of mediation.
Thank you so much, sir. Now, the parties may not have had any experience on mediation before that particular setting. So when you want to talk about your opening statement, you welcome the parties. You appreciate them for coming. Now, basically, mediation could be institutional or ad hoc. When we mean institutional, the mediation process may be at the instance of a mediation institute or a multi-door courthouse. It therefore means that all the processes are subject to agreed documentations as implemented by the institution. A multi-door courthouse or a private dispute resolution center can engage the services of mediators to help them pilot the process of mediation. It therefore means that the process will be subject to agreed standards as far as that institution is concerned. We also have ad hoc mediation. Ad hoc mediation comes to play when an individual, a mediator, is engaged by parties to help them resolve their issues. It therefore means that the mediator pioneer the process, pilot the process, and guide the process based on his personal instinct and convictions. So if you are looking at institutional mediation, the institute would have had a document that will assist the mediator to go about his or her opening statement. Whether institutional or ad hoc, the basic features of an opening statement, welcoming the parties, introducing yourself. You must make them understand who you are. You may even go ahead to make them understand the institute that you are affiliated to in order for them to have understanding and confidence in the process. You will make the parties understand that your role, you will state your role. Your role is not to impose issues on them. Your role is to assist them. So you state your role as far as the process is concerned. You go a step further by explaining what mediation is all about. Many persons, they just come to mediation with the aim of convincing the mediator why they need to have their way. So as I said, the mediator, you explain to the parties what mediation is all about. Within a short period of time, some institutions may have what they call practice direction or a little document that can enable parties that appreciate the process of mediation. If parties are with their counsel, you can state the role of your counsel. You can state the role of the parties. You may not proceed by explaining some of the terms and issues that will crop up. Terms such as caucusing, enable them understand and appreciate the importance of caucusing. Enable them to understand the importance of some documentation, like the concept of confidentiality and mediation to agree, mediation to mediate. All these are clearly stated out. And if you notice by any means, there's a little power imbalance between the parties involved. You must make them appreciate themselves to a point whereby they can open up and proceed in making sure that they're able to express themselves in clear terms. You will also go further by making them understand that each parties will have the opportunity to state their claims. Now, most mediators will want to quickly establish ground rules. Ground rules are basic and ethical agreements that help the session to move smoothly, such as making an agreement if phones will be on silent mode or if they'll be switched off, making an agreement on the language that will be used, simple language, having an agreement not to interrupt each other when any one of them has the floor, having an agreement that anything that is being said by the other party does not go down well by the second party. Instead of interrupting, you could take down. Having an agreement on agreed sections. Also having an agreement on the persons. I had one of the mentors saying, agreeing on those that will be involved in the process. There must be an agreement. I must be able to establish to the parties that as long as the process lingers, you will try as much as possible to be fair, to be open, and not to be judgmental. These are simply some of the features that we look into when we are talking about opening statement. And beyond the opening statement of the mediators, in practice, we've also been inspired to allow parties also make their opening statements. When parties make their opening statement, it gives you a mental picture of the personality you are dealing with, knowing fully well that beyond the issues, understanding the parties that have that dispute will go a long way in equipping you with the needed skill to enable them navigate through the issues at hand. Very critical. Now, looking at the other question I was asked, as far as mediation is concerned, on an ethical base, a mediator must have a good understanding of the subject matter. If I'm right, I had one of our mentors making us to understand that if not today, either in the last edition, in mediation, we have areas of specialization. Some mediators specialize in family disputes. Some are specialists in communal disputes. Some are specialists in workplace disputes. Some are specialists in different kinds of disputes. So a mediator must understand the subject matter. It is ethical. Don't forget, like we said, mediation is not just a single cap. Mediation, becoming a mediator is an added cap. You must have had your background in a different field, be it law, be it engineering, be it medicine, whatever field you may have your area of specialization. Becoming a mediator is an added advantage. So you must have basic understanding of the subject matter. Secondly, you must have good communication skills. If I'm right, I had one of our mentors specifically mentioning that you must have good communication skills. Communication is beyond knowing what to say. It's all about knowing how to say, knowing when to say, knowing why it should be said, making sure that the purpose is actualized. Basically, we are being told that communication is the transfer of information from a sender to a receiver through a channel and back to the sender in form of feedback. Information must be effective and not defective. Having said that, another ethical feature of a mediator, he or she must be confidential. The mediator must be confidential, having the capacity to absorb all that is being said without spreading it unnecessarily. A mediator does not need to be judgmental. Yes, it may happen that the scenario before the mediator may have a first-hand experience or encounter with such a thing. In one of our trainings, one of the panelists brought this up, that a landlord and the tenant had an issue, and they submitted to mediation. What was the issue? The tenant complained that the landlord keeps on increasing the rent of the apartment without due notification. Immediately said that the mediator said, that is exactly what my son is going through in the place he's staying. He had the same issues with his landlady. Immediately the mediator said that the landlord that was in that mediation section quickly drew the attention of the manager of the center, saying, For the mediator to say this, he or she is already taking side. A mediator must not be judgmental. Is it possible? Yes, it is possible. It may not be possible at a go, but over time it is possible. We don't need to take side. If you belong to a religious faith and a party among the parties that are before you are in the same religious faith like yours, it doesn't mean that that one will be right. You must not be judgmental. Now, a mediator must have the skill to assess the emotional state of the parties. In other words, a mediator must be emotionally balanced and emotionally intelligent. There's a training called emotional intelligence. You must be emotionally intelligent to know that the fact that a party is eloquent and the other party is conserved doesn't mean that one has one advantage over the other. You must be emotionally intelligent to know that beyond words that has been said, silence may mean so much. I was opportune to have some parties before me, a couple and another people. One of the husband didn't say anything throughout the session. The wife kept on speaking, and there are some points the wife will make. The man's gesticulation will tell me if that position is valid or not. Now, the mediator must understand that while parties are speaking, if you tend to smile or nod your head when one party is speaking, you must endeavor you do so when the other party is speaking, for the parties not to feel that you are siding one side or the other. When parties are before the mediator, it is ethical for the mediator to assist the parties in separating the problem from the parties. It is obvious and usually the case that a party feels the other party is the problem, not knowing that we can separate the person from the problem in order for us to understand what the issues are. We all know that conflicts are inevitable, and one of the fundamental factors that fuel conflicts is difference in perception. I always say this: the fact that you are right does not mean you can avoid conflict. Someone sees a cup of water and says this cup of water is half full, and another person says this cup of water is half empty. They are saying the same thing from different perspectives. An individual is seeing 9, the other individual is seeing 6. Are they correct? Yes, they are correct. But the accuracy of their individual position, when brought to a joint section, will definitely fuel conflict. What are we saying? We are simply saying that the mediator must be emotionally intelligent enough to understand how to balance the power play between parties. It is usually the case that many times a party can speak for 2 hours and are unable to establish the fundamental issues before them. Yes, party makes their statement. Yes, parties make filings. But beyond what is written and beyond what is being said, there's a difference between their needs and their interests. So the ability to enable the parties understand the difference between their needs and their interests is very vital. Now, looking at it from a very basic angle, we are being told in economics that our needs are different from our wants. Many parties come into mediation because of what they want. But the mediator can assist them understand what they need. And I be very clear with you. Most conflicts I've seen where parties come into mediation thinking they understand the conflict, not knowing that they have not understood the conflict. But in the course of the mediation, it becomes clearer. Now, don't forget I said earlier that we should have our area of specialization. When it is obvious, one of our mentors talked about getting an expert witness, getting an expert determiner to add value to the process. When it becomes obvious that there is a need to engage the services of professionals, nothing stops you from suggesting to the parties. We had a matter before us based on, we were able to streamline the issues, and we were now brought to the point of authenticating the signature on a document. One of the parties said, "This is my signature, but I did not sign this document." Having settled other issues, that was the only issue left. "This is my signature, but I did not sign the document." What did we do at that point? We have to seek the services of a forensic expert. A forensic expert was called upon, and before they were called upon, both parties had to do an undertaking agreement to engage the services of a forensic expert to go through the process of expert determination. And they agreed, whatever is the outcome of this process, we are stuck with it. So these are many more some critical and ethical features that we have in mediation. And a mediator should be able to know when to adjourn a session and when to call for caucus. I want to quickly add, a mediator should have the ability to rephrase. It is not what is being said most times, but how it's being said. There's a way to say good words that the meaning will be lost. And there's a way you will say words that are not too attractive, but in a polite way that the impact will be reduced when it gets to the other party. So a mediator should be able to rephrase words. A mediator is a constructor, enables him to rephrase and construct a language either in a joint session or in a caucus. An individual may have something to say to the other party. The way the party will say, the way party A will speak to party B may escalate the conflict, escalate the tension, or de-escalate it. So you see, the mediator is there working for everybody for the purpose of resolution, not undermining the fact that resolution is not by compulsion. It is possible parties settle. It is possible they do not settle. But at the end of the day, they've come to appreciate the process of mediation. And like I said last week, if at the end of the entire process, parties are unable to settle, what is the role of the mediator? The role of the mediator is to help parties understand that the door of mediation is always open. We may want to switch to another door among the spectrums of mediation, or let them know that the door of mediation is always open. There may be so many issues at stake. We have always been told, we've always been encouraged, don't lay too much emphasis on the issues that bring disagreements. Try and lay emphasis on the issues that unite them. If 60% of the issues escalate tension, see how you can magnify the 40% that brings about cohesion between two couples or between a couple seeking for, they want to go their separate ways, and the issue of property comes in. Who takes this? Who doesn't take this? Who takes this? Who doesn't take this? Now, there must be a common ground. Do they have children? If yes, how many children do they have? If on a personal level, they have made up their mind to do X, Y, Z, see the level of affection and attachment they have to their children. I believe the rational man will be able to let go X, Y, Z for his children, for their upbringing. Having said so much, we must understand that there's no golden bullet in mediation. What do I mean? No two mediation case is the same. They are all dynamic because the persons involved are dynamic. When you have a party coming in with their counsel, we've seen so many cases whereby the mediator will tell the parties, mediation is party driven. We don't want the lawyers to be among us. Lawyers, please do not say anything, keep quiet. The way you make a best so you now, parties come to the mediation center with their counsel because they believe in their counsel. Most times, counsels have added tremendous value to the process. When you know I have been able to handle sessions whereby I do caucus with the councils and say I can enable them add value to the process. By the time we are meeting with the parties, the case is half resolved. Learn to make most of what you have. Appreciate them. Let them understand the need to move forward. Sometimes I usually use this scenario. The former Vice President of Nigeria, Professor Simbajo, said once that on the average, education matter has a lifespan of between 10 to 16 years and above. When you help people understand time value for money, they may have a rethink. But in all you do, seek to inspire them. When your opening statement is well structured, it gives you control over the entire process. Mr. Lachan, I hope I've been able to.
Thank you very much, Mr. Samuel, for that contribution. It was wonderful. So we have Mariam. Mariam is also here with us. Mariam, will you want to say one or two things briefly? Is Mariam still with us? Okay. So Mariam, is Mariam with us? Okay. Now we have looked at we have considered discussion we have discussed the various career opportunities in mediation. We have also looked at I know some of the principles of mediation. We have looked at the stages and processes in mediation. We have also discussed agreements to mediate and its significance. And we have also looked at terms of settlement. These are some of the things that we have looked at thus far. So, okay, please. So, Natalia, can you would you like to say something briefly on the principles of mediation? One of the group have mentioned, but I don't think they didn't actually explain. They stated in their, that's group 1, they stated they have done a good work, but the presentation was not as expected. So they have in their this thing about they have neutrality, flexibility, confidentiality, voluntary participation, self-determination, and focus on interests. Will you want to just say something briefly on that before we proceed?
Okay, I just want to say that that the bedrock of mediation, which is one of the principles, is that, I mean, it's confidentiality. That bedrock is one of the key principles, which is one of the things that they mentioned. I'm looking at their, that part of it. As a mediator, you must be neutral, because if the parties don't find you neutral, they can't trust the process. And because when you tell parties that the process is confidential, it means that both from the moment you come in to the moment when you finish, everything discussed there must be confidential. Even in private sessions, we should call caucus sessions, right? So, and as a mediator, your neutrality is just by words of mouth. It must be seen by the parties that you are actually neutral. And so the moment the party sense that you're not neutral, that process is affected. How do you infringe on neutrality? So when the party makes a comment or says something and you affirm, either by your words or your body language, because the language is not only limited to verbal, expression, but the body language, which includes the eye contact, body movement, and all of that. So if the party senses that you nodded your head in affirmation, to what the other party said, you as a mediator, your confidence, your neutrality is being questioned. Some may not say it, they may not speak it out, they just keep it to themselves. But it will affect how they carry on. So you must be very careful in carrying on with that. And like Samuel said, at the very beginning, while you are making your opening statement as a mediator, you must point out all these key elements, because like he said, it sets the tone for the entire process. So if you don't take them through, mentioning all these aspects, these principles, the parties would get discouraged. More importantly, again, is when we say active or voluntary participation. So when you come in, some people will come into the session and they will not say anything. So that's why as a mediator at the very beginning, you must prepare their mind and let them know that they have to take charge of the process. And as a mediator, you must give them that room to express themselves. Only speak when it's necessary. Don't interject. You must let parties be involved. Let them know that they can't just come and keep quiet. Whether they are coming alone or coming with their lawyers, it's important that everyone who is there gets involved. Because the reason why it's important for them to be actively involved and allow them to run the process themselves, which is why we say it's party driven, is essential, because at the end of the day, whatever decision we take would come from, they won't say it was the mediator that told me to do this, right? It was the mediator that told me to do that. They must see, you must allow them decide for themselves. You only help them to facilitate the process, or where you notice that, oh, these people are getting into deadlock, then you can step in to see how you can help them, resolve it. So these principles of confidentiality, neutrality, impartiality, time saving, it's, that's one of the principles, one of the reasons why we come into mediation, because we know that when we come in, we're going to save our time. So you must explain all these principles to them and let them know that the final decision lies with the parties. So while talking about neutrality, confidentiality, if you take those things away, then it's as good as not, having a mediation session, because you can come there willingly, but like someone mentioned, was it someone or someone saying that, okay, it was Eunice that said, imagine where you don't inform the parties that they must not record, and somebody is taping what you're saying, and even at the end of the day, it doesn't work out. It's now all over the social media. So confidentiality, is not only within that session that is going on, but must also continue even after the session. And that's why it's important that document is actually, signed at the very beginning. It's very important. Let me share quickly an experience I had. There was a particular period where I always make sure that parties sign before we commence the session. So along the line, I had forgotten to sign. I allowed them to sign the agreement to mediate and the confidentiality form. So along the line, I remembered and I asked the parties to sign. Some signed, some did not sign. They insisted they won't sign. And for me as a mediator, it was a wrong, step I took. No matter how much the parties are in a hurry, please always make sure all these forms are signed at the beginning, because part of those forms that are being signed is that confidentiality, very important. And it also protects you as a mediator as well. So it's important that you let the parties know that they must sign it, and they are bound by those rules. And that's the reason why we say that even after the session has ended, no one can call you as the mediator to come to testify in the court of law, because a lot of things within your that you possess, both at the open session and at the private session with the parties. And that immunity, I think it's section, is it 82 or so of the new act that protects the mediator, gives you that immunity whereby no one can call you to testify and no one can call any of the parties there. So it's important really that those things are clearly spelled out. Let them know it's time saving, time consuming. So it's time saving rather, save money, mention those principles, and let them know at the end of the day, it's party driven, decision is taken by them. Thank you.
All right, thank you. Thank you very much for
let
that.
me quickly, sorry, please, Nanshang, I want to add something that at the very beginning as the mediator, please, it's important that you set the agenda. That agenda, and that's why during your opening remarks as the mediator, you must point this thing out. Let the parties know how the whole process will run, apportion time to them, and let them know who's going to speak first and how many minutes each of them have. And then tell them at the very beginning, this is how much time we are going to spend. If it's 1 hour, let them know at the very beginning. If it's 2 hours, let them know. And then you apportion the time for opening remarks for each of the parties. And it's not compulsory that you must finish that session in one day. You can adjourn the session to another day so that parties have time to also reflect on the progress that has been made so far. Thank you very much.
All right, thank you. We appreciate you. So quickly, let me just summarize what we have learned thus far, and then we'll give room for questioning before we close for today. Now, we have been able to look at opening statement, we have been able to consider. Okay, can you see my screen?
Yes, sir, we can see your screen, but it's your WhatsApp that is open, sir.
Okay, yes, I wanted to share the content of that from the WhatsApp of some of those. Okay, don't worry. Okay, now, so we were able to look at what mediation is. Mediation is all about negotiation, but the negotiation that is assisted by a third party neutral, and that neutral is called a mediator. And when this mediator is appointed to do a particular thing, the parties are the one who decides. The parties are the one who will appoint the mediator. The parties will choose who is going to help them resolve their disputes. The parties are actually in charge of the entire process. And when it comes to the principles of mediation, you must understand that there must be neutrality, there must be confidentiality. The mediator must be in the middle, not this side or that side. And then there must be confidentiality. All that you discuss, all the parties, the mediators are bound, and whatsoever they discuss
He's not going to get to anywhere. He's not going to go to any place. He's not going to be heard anywhere. That's one of the major principles that our friends has explained. Flexibility, you can decide to sit anywhere. You can decide to meet anywhere. You can reschedule your meeting. You can meet online. You can meet physically. You can choose you can choose to do your meetings the way you want it. You can choose the timing. We want to resolve this thing within 1 week, so let us sit every day. So these are some of the things we have looked at. And then voluntarily, there is no any coercion. Everybody has his own free will. He can choose when to do what he wants to do. And you cannot say you must attend this session because this thing is very important for us. Please, can you confirm if you can hear me?
Yes, sir, we can hear you, sir.
So, and then we have looked at that with self-determination. The parties at the end of it, after all the options that are available to them, they will choose what is the solution for their problem by themselves, not the mediator imposing it on them. Very, very important. And then, at the end of it, you are going to resolve the matter based on parties' interest. That is what is of interest to them. Interest-driven kind of mediation, not you are just saying this is what I want to do and there is nothing that will stop me from doing it. This is what I want. If you cannot pay this, then forget about everything. No, you shift grounds in mediation. So that is some of the things that we have looked at. Now, when it comes to processes and stages in mediation, it's very, very important for us to know that the stages. Now, our brother, one of our mentors has explained that we will need to. One of our mentors has explained what we need to do when you come to a mediation session. Very, very important. You need to know how to start the mediation session, how to start up set up your agenda. Let the parties know what brought them and the things you are going to be looking at for the peaceful resolution of their disputes. That is very, very important. And then parties must also understand that it is in the course of their opening statement that they will be able to help the parties know the processes that is involved, what the process is involved, whether someone has attended the session before or not. You have to explain to them what mediation is, because you cannot assume that everybody knows what that thing is. So having done all the necessary things, you need to prepare. Very, very important. Do your preparation. And in your preparation, you ensure that you have a convenient venue for your meeting. That venue is the place that is devoid of noise, not a place where, when you are meeting, somebody will be shouting and saying one thing or the other. Then the opening phase, after you've started your meeting, you need to do your introductions, and then that introduction includes your own introduction, your opening statement as a mediator, and then what the parties their parties' opening statements. So after that is done, you need to confirm if the person that is in the mediation table has the authority to decide. It is not when you begin to discuss and agree on important issue, the person will say, let me call the director. I cannot actually decide this thing. So you need to be very careful. You need to confirm that the person who comes has the power and the authority to decide. And then in your opening statement, you have already guided them as to what they need to do and what the mediation session is all about, the important principles of the mediation session, including, talking, one person talks at a time. If you have any issue or you want to react, just take note. Don't just talk randomly. You have to take an excuse and all of those things. Parties will make their opening statements, and then you go to the exploration stage. This is where, you begin to understand the interest. Why does this person want this thing he's claiming? Say, I need my money plus interest. You need to understand why this person is saying that he needs interest. He needed to do something. I needed to do something, and then you say you supply rice for me, you didn't supply, so I have to go and buy at a higher price. These are some of the things that you'll be looking at, and then you understand why this thing is being done. So this exploration stage can be in a joint session where all parties and mediator is there, and at the point you may need to go for caucusing. These are some of the things that you go. You have a personal meeting with the parties to be able to discuss or understand what is actually their interest. What are they trying? What are they looking for in this? And then you go to the negotiation phase, having understand the real issue. You go to negotiation phase. Say, you have to pay me my money with interest. I don't have cash to give you. I can give you a goat. I can give you some yam because I have. Will you accept it? That negotiation takes place. And then at the end of it, if parties agree, that you have gone to the end of that, parties have resolved. So you need to settle everything. Everything parties have agreed on, you have to write them down. Write them down very clearly, what they've agreed, the amount they are going to pay, when they are going to pay, how they are going to pay, and all of those things. You have to take note of that. Those are the processes and the stages. And then we look at your opening statement. As an opening statement, you mention your name as a person, the institution where you are trained, and some of the things you have been doing, so that the people will know that they are staying before a competent person. I have been conducting mediation proceedings for a while, and then you can see things like this. You ask the parties to introduce themselves, thank them for choosing mediation, because it's not everyone who will even come for the session. It's voluntary, and you cannot force anybody to attend the session. These are some of the things that you do during your opening statement, so that parties will be able to understand what brought them there. So if it is an online session, you establish the rules. If it is physical session, establish the rules, and then explain to them how the meeting is going to go. All these things are supposed to be contained in your opening statement. So after you do all of these things, you have to find out from them whether they understand the process. Do they have anything to add to the process on what needs to be done or not? If they say there is nothing, then you are done for the day, that you are done for that moment. So we have looked at the processes and stages. Sorry, I'm taking your time, because this is one of the very important things you need to know. You are going to start your practicals the next a week after the next week we have. So this is very important. Your agreement to mediate, you collect it first. Get them sign it, so that somebody will not come and tell you that I don't really know what it is. I don't even know what it is like. So after all of those things, sign the agreement to mediate, include your fees, include confidentiality, include whether you are going to take the matter for enforcement before the court, and all of those things. Include them in your agreement to mediate, so that someone will know what is actually going into. And please, are you with me? Can you hear me?
We can hear you, sir.
Yeah, so finally, on the some of the how do you resolve deadlock, where you try your best and the thing is not working. If you are remember, as a mediator, you have to be committed to the process. Don't, by your own action or your own will, just chase people and say, okay, it is not my problem. If you don't want to resolve the issue, what is my problem? Please go with your problem. No. You have to be committed to the process. As a mediator, you must be committed to the process. If you have done your part and there is deadlock, one of the ways to resolve deadlock is to break the parties into caucus. When you break the parties into caucus, you'll be able to do some reality testing. Somebody is saying, I need compensation, I need interest, I need this and that. You are going to ask them very frank questions, straightforward question. Please justify this thing to me. Can you explain to me how you are you should be entitled to so amount of money? Why this should be done like this and like this? You are claiming 50,000 naira. How much are they selling a bag of rice in the market? You know, all of those things, you do it in the caucus session. These are some of the things that you are going to do as a mediator to help ease the burden. Sometimes you take a break. Okay, can we just take 5-10 minutes break so that we'll take some fresh air and then, you know, we come back? Because when someone is frustrated, he can actually decide to, he can actually frustrate the entire process. So these are some of the things that I feel we should all know. And so with this, we have been able to cover some of the agendas that we have for today. So Dennis, I think we have done justice to the topics. So over to you, in case anyone has a question or clarification before we call it a day.
Thank you so much, Mr. Nacham, and thank you to all our mentors for this wonderful session that you people have helped facilitate. Thank you, Mr. Nacham, for helping us coordinate our mentors' feedback and also their briefs or their discourse on the topic for today, mediation and career opportunities. Now, our mentors have been saying a lot. They've said a lot, right? So we want to give opportunities to our mentees to now ask questions, because I know in the midst of the several things that was said, there may be a thing or two that our mentees properly did not understand, right, and they may need some form of clarity on. So please, we are taking questions from our mentees. You can drop your question in the chat box, or you can just indicate so that we can call you to ask your question. So please, if there are questions, we'll be taking them now. Our mentees, please go ahead and ask your questions. We encourage you to ask questions. Questions help the learning process. It helps confirm that you were listening. It also helps confirm to us that you were paying attention to everything that was said. So please, we are taking questions. Does anyone have a question? Okay, I can see Mr. Augustine's hand up. Please, you can go ahead and ask your question.
Okay, good evening.
Yes, good evening, Mr. Augustine. Yes, you are audible.
While our mentor was, teaching, she made mention of caucus section that, in as much as they have confidentiality during a mediation, there is also a session called caucus session. That's a private session. I didn't get the explanation very well, and I want her to throw more light on it. Thank you.
Sorry, thank you very much, Mr. Augustine, for that question. I think it was Miss Natalia that made mention of that.
Natalia, let's not stress Natalia too much. I can see that Eunice is back. So Eunice, one of the mentees is asking about caucus, that in the course of the mentorship, there was a mention about caucus and a general session. So can you shed more light on that?
Okay, thank you. I believe Nathania is not tired, but let me answer. And thank you for calling me again.
We don't want to stress her because we'll bring her back again.
Okay. So when you're talking about caucus meeting, it's a private meeting. Let me just break it down. In your opening statement, you must have mentioned it that during the course of mediation, you may want to break into different rooms. Because there's some time that even though you said the process is confidential, parties may not trust the other party enough to divulge some information. Or sometimes when you notice that there is a deadlock or it's becoming, we're not making any progress in the mediation. So the mediator decides that, okay, I want to break into private meeting. If you're having a physical mediation, you can, if you have other room, you take the party that you want to meet with to the other room, and you let the other parties know that, okay, I'm going to have a private meeting with this party A. And whatever we discuss in that meeting, except party A said I should tell you, I will not be revealing that to you. So that gives party A the confidence to open up to you in that private meeting. That's what is called caucus. It's just private meeting, shortening between one room and the other, just to meet party. But you know, because we've talked about the principle of neutrality and impartiality, you have to make sure that you balance it. You don't just meet with only one party and leave the other. That, okay, I will meet with party A first for 10 minutes or 20 minutes. Then I will come back to party B and also meet with party B. And whatever we discuss with party B as well will be confidential, except what party B says I should. And when you meet with party A and you say you're going to spend 10 minutes and you spend 15 minutes, you have to explain to party B when you come back. And I thought, oh, it takes a long time, but because we have a lot to talk about, then try and balance the timing you spend with party, because party could be very petty when it comes to the, okay, you're spending so much time with this because so that you don't compromise your impartiality with the party. So that's just what private caucus means, that you are meeting with party differently to understand how they are thinking, to understand their point of view. Sometimes in that private meeting, you play a devil's advocate. That's when you do your reality testing. I hope you understand what reality testing is. Like, you give them a scenario that, okay, what's your best alternative if you're not able to resolve through this mediation? What is your worst alternative if you're not able to resolve? Is the private meeting that allows you to talk about it, so that party can be vulnerable with you. And it will help you as a mediator to know the next line of question to ask, and you'll be able to move the process forward. I hope I'm able to answer your question.
Yes, thank you very much for that. I believe that you have done justice to that. So we have another question here. Okay, thank you, Miriam. Miriam has attempted some of the questions. So I'm seeing a question here. It says okay. It says it is great. It is important for mediators to establish the authority at the point of making the opening statement, so that parties can have confidence in both the process and the outcome. Thank you, Mentor Mariam Osiri, for that wonderful contribution. Then a question here, say a clarification touching the mediation process. Even though parties are not allowed to record the session, can the mediator do so, according to Williams or Suntoki? And then also, is the whole session, that's everything discussed, subject to writing, or only the agreement is subject to writing? So that is the question that is asked. I don't know who else is here that will, Mr. Samuel. Okay, Natalia, you saw the question. Natalia, you can attempt those questions just briefly and shortly, please, so that we can attend to Olua Timilehi. No be small thing. Please, pardon me for murdering your name. Natalia, you attempt it so that Olua Timilehin can ask, then Gloria, all the way from Ghana or Kenya. Gloria, can also ask her question.
So okay, thank you, Nanchang. I didn't get a question because I'm looking.
The question is that the parties are not allowed to record the session. Can the mediator record the session? That's one. Number two, is it the whole session? Is everything that is discussed, is it subject to writing? Is it everything discussed in the session that is subject to writing, or only the agreement that is subject to writing?
Okay, thank you very much. To the first question, the answer is no. You cannot record the session. whether like we're having physical meeting or you're having an online session, you cannot record it because that is a breach of confidentiality. And once that happens, it puts party to be they will no longer be at ease because they feel that what they have said will be used against them. And if you as a mediator during the session, you find out that the parties are recording, you have to stop them and ask them to delete whatever they have. I've done that before to senior lawyers, to SANS, to parties. You cannot record. And that will not be used. And it's worse during online mediation because you're not there physically with them. They may have a device that is recording everything without your knowledge. So if in that kind of situation, you are covered because the new act, the Arbitration and Mediation Act, gives you an immunity that even if somebody recorded it without your knowledge, right, an inbuilt device, then it means that even if they decide to tender it in court, that will not suffice because the rule of confidentiality says you cannot record anything about what is contained in the mediation agreement. So it's not everything you say, everything you discuss. No, it is what the parties have agreed. So there's a dispute that brought the parties before the mediator. The moment they have agreed and said, okay, we are settling on this, everything they have agreed upon will now be reduced in writing. And what is reduced in writing, the mediator will go back again, ask the parties, have you looked at, they have to look at it again and be sure that that's what they have, agreed upon. And then it's drafted. After it is drafted, they go through it again, make corrections where necessary, and they look at it the final time before they now go ahead and append their signature. So the important thing is what the parties have agreed upon. Then I want to quickly ask, I saw a question that has to do with authority. Somebody was asking who is or are the authority or the party authority to mediate. Your authority to mediate as a party is that you have be able to take a binding decision. Some people come to the mediation, they say, my boss sent me to just come and listen. No, you don't come to just listen in mediation. You come and be involved, and you have an authority to be in that as a party, and you have an authority to go ahead and mediate. It means that that's why during the time you are signing that mediation agreement to mediate, you will state not just your name, but your position and in what capacity you are acting. So if you're not the MD and you say, I don't have the capacity, that is when the mediator will demand that you produce a letter of authority saying that you can take a binding decision. That is whatever you say in that mediation is final. Because some people will say, let me go and verify from my MD. I cannot take a final decision. And that's why as a mediator, you have to always insist that the right parties are in there. I saw Miriam's response, and she was speaking to the aspect of being a mediator. Yes, for you to have been appointed to sit down there, it means that already you have that authority. Just like Miriam said, you have the authority as a mediator. But the authority I am talking about right now is authority as a party. People who have the right to be in that room and take a decision. Thank you.
Thank you very much. So to add a bit, authority, anybody who is coming to represent another person, if you are the person yourself, you apparently have authority. But if you are representing another person, you must ensure that you have the authority to represent the person, and that authority can be written, can be a power of attorney, it can be a letter of authority, so that you show that you have what it takes. And that's why before you commence your session, you must confirm from the parties whether, if they are not representing themselves, confirm from them whether they have the authority to settle their to settle. The settlement we're talking about is when it is time to make decision, you will not say, I cannot take this particular decision. I have to consult with another person. We need someone who can call the shot. We need someone who can decide the thing by himself, there and then. That is the persons we need at the mediation table. Thank you very much for that wonderful contribution. And so, Olua, Timmy, can you ask? Then Gloria.
Okay, thank you very much, sir. And you can just call me Timmy. My name is quite exhaustively long. Okay, so yes, thank you to our mentors for that wonderful session. So I really would love to ask, because today we're talking about opportunities in ADR. So I, for one, I've gone different trainings for ADR, and my university, we have a society, the last ADR society. I do not know if Miss Natalia remembers, but she was one of our trainers for the panel of neutrals for our last ADR society. It's so nice to meet you.
I remember you.
Yes, it's so nice to meet you here, ma'am. So the question that I have is, as a student, right, there's this campus, and they're telling us that as students we can become mediators. So I would love to ask, is that really feasible? And even if it is feasible, as a student, when we become mediators, then how do we go about taking cases and whatnot? Because we've underwent the training. I, for one, I'm going to any training, I see that there's ADR to gain more knowledge. So I would love to ask, whenever, how do students as well harness these opportunities that are in ADR? That's just the question that I have.
Thank you, Timmy. Olua Timmy. I will learn your name. So chat me so that I will learn your name very well.
Okay, sir.
Mr. Samuel. Is Mr. Samuel with us?
Yes, please.
Please, did you hear our question?
Yes, please. I had a question. I think it bordered on how to actually grow her skills as a mediator and to confirm if as students you can actually become mediators.
And whether they can take cases and make money. That is the important aspect.
Okay. Thank you so much. Thank you, Timmy, for your question. And thanks to all our mentors in the house. Once you've been trained and you've been certified, you are a mediator. But we all know that according to George Orwell in Animal Farm, all animals are equal and some animals are more equal than others. Flowing from that, you must understand that the journey of 1,000 miles begins with a step. When you've been trained, what next can you do? There are a whole lot of persons that have been trained, there are a whole lot of persons that have been certified, and they think manna will just fall from heaven. Whenever we have this opportunity, we always bring to the fore. They need to undergo mentorship. Exactly what we are doing. They need to volunteer because of the confidential nature of mediation. You may not have the privilege to just walk into a mediation center, to walk into a mediation process and observe what is happening. So there may be the need to identify mediators, to identify institutions, to identify dispute resolution centers where you can notify them, I have been trained by XYZ Institute and I would love to hone my skills. There are ways that a mediator or a dispute resolution center can co-opt you. Most times, some institutes, they do settlement week, they do a lot of programs, they do a lot of activities that you can take advantage of. You may not be a mediator, you can be a co-mediator in a process. I believe that I once had an opportunity in my early days of mediation. A mediator was assigned to a matter and he went into the session with me. And he introduced me. I have here a young man that will help us take notes. And if you need one or two things, he can assist you with the process. Introducing me and seeing me with that big mediator gave the parties confidence that this guy must be credible. And that was how we all began. You must volunteer. It is good to know that we have career opportunities, but you cannot start making money overnight. I must also add that having one training is good, may not just be good enough. If you take a look at the profile of all mentors here, you will discover that we have one thing in common. We've undergone training from different institutes in ADRO. When you talk about training, it is a world of endless possibilities. Go through trainings, identify with different social networks, volunteer yourself for voluntary activities. See how you can tag along with some mentors in joining them for sessions. One of the mentors talked about doing research work. You can do research work. You can do write-up. There are different things you can do. Personally, when I came on board the ADR space, I discovered that you just need to make a way for yourself. When no one was there to open the door, I started organizing webinars on my own, all expense paid, organized webinars, designed flyers, posted it, circulated it. The first webinars, few persons joined, it became a monthly thing. What was I doing? I take my time to do research, carry out research. It is one thing to know, it's another thing to know how to communicate that which you know. And people don't really care to know how much you know, but how well you can impact the little that you know. I started organizing webinars. I started reaching out for adverts. What opportunities are there? What can I do? When I don't have time to do webinars, I do write-ups, circulate it on social medias. People are beginning to understand you. People are beginning to see what you do. You may think nobody is seeing you. Funny enough, I got a call one day and said, we've been seeing your webinars. Can you do this for us? I gladly said, yes, I can do that for you. You must understand that what you know today is good enough for today. Once the day breaks, there may be something new that has been added to the space. So you must be open up for knowledge. You must be open up to training and retraining. It may
Thank
be
you very much, sir. Thank you, sir. You have over. In fact, you have put too much Jara according to our people over here. You put so much. So, Gloria, let's hear you before we go. Okay, Eunice want to say something. Let Gloria ask her question, then Eunice, you answer the question and then say what you want to say, then we close.
Thank you so very much. Our mentors have been so wonderful. And then my question is almost in line with what Timmy just asked, but then in another form, in the sense that I want to ask, meanwhile, I want to thank the last speaker that really answered the question. He really made it so extensive and very, very, very understandable. Okay, now I want to ask, please, what other qualifications do we need to really be properly called ADR practitioners? And now can we, with this particular mentorship program we have, with the certification from this now, is it enough to really begin to fix ADR practitioners into our names and probably begin to call ourselves ADR practitioners? And what other things? Because I actually see that most all of our mentors have lots and lots of qualifications, even internationally. So that we really need to go through all that before you can really begin to act as an ADR professional. Thank you so very much.
So where are you calling from, Gloria?
Port Harcourt, sir, in Port Harcourt, Nigeria.
Seriously, you're sounding like a Ghanaian or Kenyan, all of those kind of things. Are you in Nigerian?
Yes, sir, I'm in Nigeria, sir.
Okay, that's interesting. Thank you. So,
Thank you,
Eunice, please.
All right. Gloria, I love your smile. You have a very good disposition. Yeah, and that's contagious. You see, you're already a mediator. Like I say, I saw a quote somewhere, and I always say it, that confidence does not come when you have all the answers, but when you are ready to face any question. That's where your confidence builds. There is nothing bad in saying, oh, I don't know this now, but I'm going to check it up with confidence. Say it. Like Samuel had said, you have to create, and thankfully for mediation, it's not that really regulated now. Yes, there is AMA, but there is nothing that says that you must have this qualification before you can call yourself a mediator. Before we have all these trainings, we have people mediating. It's just that it's not called that mediation name. You call yourself, people call me Eunice because I told them my name is Eunice. If you tell people you are a mediator, they may not believe it, but with time, as you continue to say it, oh, she's a mediator. And what do you put outside there? Social media has so much helped us so well that you can call yourself anything. Whatever you call yourself, that's what people call you. You necessarily do not need any certification per se to be a mediator. You are a peacemaker. But because we want people, Nigerian, we so much particular about certificates and to give validity to your skill. That's why we go into training, that people will know that it's not just by word of mouth, then you walk the path, and we're committed to learning and learning. I want to say that, Timmy, are you a student? Gloria, are you a student?
Yes, I'm a law graduate waiting to be called to the bar.
Oh, fantastic. There are many of us here that you volunteering, please. Money is not the first thing. Volunteer. What can I do for you? Can I write for you? Can I attend a session with you? All of these things give you experience. And before you know it, your confidence is built. When you have forum like this, we bring ourselves together, you speak and people listen that, oh, so she has knowledge. But if you're shying away and waiting for somebody to create a table for you, it may never come. So you have to create your own table. If they don't invite you to the table, create your own table and invite people on the table, on the scale. Create a profile. I am a mediator. That is who you are. I am a negotiator. And now continue to hone your skill, to develop yourself. Similarly says she's a student. In your school, you can start a mediation clinic in your school and have students refer matters. And you use them as guinea pig. Do the mediation for them for free in school. When students, the hostel dispute, they bring it to the mediation clinic of the law department. And you start a process through that, you're building your skill. By the time you leave, this is your colleague, this is your school people. They are still the one that will need your service in the marketplace. And because they are seeing your skill when you're in school, they will have no doubt to call you. What do you post outside? What do you write outside there? I've had many articles that I've written in the past, and people call me from all over Nigeria that we saw this article and they consult me that appears you are an expert in this. And we will not stop there. We continue to build our career. We continue to read. And thankfully, there are so much materials that you don't need to pay for out there. If you sit down 1 month, I want to know this, I want to master this, you will know it. But mediation is by practice. You learn by practice. So you have to just find a way to attach yourself to someone, a practitioner that you see that this person is active. How can you help my career? We've mentioned it's not just by mediating. You can be a trainer. You can be, you can facilitate events. You can facilitate training. You can train in organization, in institution. You can even be an HR person. What more do you need to put out there? Create a niche for yourself and let people know you for that. I dance. If you go on TikTok, I am there. And I put the peaceful vibe. I have my YouTube channel. I am there. When I came into the UK, I showed myself. I put myself forward. I volunteered. And before you know it, when they want to do their Law Society conference, they nominated me because they see how active I've been, that I know my onions. People will not just come and throw things at your table. You have to put yourself forward. I can do it. Yes, some of us are conservative. I used to be a melancholy that, I would rather sit back. You don't want to make mistake. You want to be perfect. But when we're waiting to that perfect time, you may never achieve anything. So just take the bull by the horns, make mistake and learn from your mistake. If you don't make mistake, how will you know how not to make mistake? Make that mistake, fumble. But you learn to reflect. What did I do right this time? What can I do better? And before you know it, you are master at what you're doing. Let people know you. Create your own profile. Your LinkedIn, please don't play with LinkedIn. LinkedIn is where you see serious-minded people. So create your LinkedIn, do your posting. Even this mentorship program that I just attended, what is your takeaway from this conference? Take it on your LinkedIn page. I am so blessed with these people today. I learned this, I learned this, I learned this. So with that, people will be seeing you, be noticing you. How did I know Nachand? It was through all this interaction here and there that we get to know each other. And if I have a call, oh, Nachand, I've seen this opportunity. You call them. You call your colleague, okay, I know this person is able because I've seen what they have done before. But if nobody has seen you, how would they recommend you? So you have to put yourself out there. You don't need to have all the certification there. Yes, it's good that you are doing all of this. Put it there to validate your skill. But don't wait that when I have this, then I'll be able to tell everybody that this is what I can do. You can do anything, even right now.
Thank you very much, Eunice. I can see my Oga Samuel, I see your hands up. Are you part of the
Yes. I just wanted to quickly chip in this in 3 minutes.
Yes.
I heard of ADR for the first time in the year 2020. It may sound strange. So between 2020, towards the end of 2020, September, October, and 2024, I've been able to do the little that God has enabled me to do. Where there's a will, there's a way. Like Eunice said, you must have a starting point, brand your skill. I registered a business name with CAC. Get a brand. Like she said, get a brand. You have your social media handle. You have your WhatsApp status. That's the most simplified social media handle. What do you put out there? What do you do? Get a brand and pursue your purpose. Don't forget, it doesn't rub off your primary discipline. It doesn't rub off your primary area of specialization. You can get a blend. We have so many lawyers. Their chamber is both a law firm and an ADR center. There's a lot of things you can do. And please stick to Nachand because he's a man, he's everywhere, he's a man of the people. Volunteer. There's something you can do. ADR is an opportunity where you can bring to light your personal skill and your personal talent. Under 4 years, I've done this little and I hope to do so much more. You can chase your dream. We have people that have spent 30 years in this field, 40 years in this field, and they are looking for young minds that they can breed to make the world a better place. So keep your passion alive. We are moving forward. Thank you.
Thank you very much, sir. Olua Timmy, your hand is up. Is it by mistake? Timmy?
Not exactly. Good evening, sir.
Yeah, good evening.
Sorry,
yes.
Can you hear me?
Yes, I can hear you.
Okay, so I had issues with my network.
Okay.
Okay, so my network went off. So all I got from what the speaker said was to volunteer, put myself out there. But I would love to ask, the speaker also mentioned that, they got an opportunity to be a co-mediator. So I would love to ask, is it that there's a place you can apply to actually, watch some of these proceedings, or there's or you could just, walk into the multi-door courthouse because I know mediation is confidential. They would not just allow you to view proceedings. So how do we go about that? Or how do I go about that?
Mr. Samuel, please conclude. Let us pray and go.
Let me quickly ask, what state are you residing in?
Okay, sir, I'm all yes.
What state are you residing in?
Which state are you?
What state are you residing in?
Oh, I reside in Lagos State.
Beautiful. Awesome. Now, Lagos State.
Is that the question?
Yes, please. In Lagos State, there are a whole lot of opportunities being the center of excellence. you have different area institutes and a whole lot of openings. What I can say now, you can reach Nachang or you can reach me at the end of this class, and we can see what best we can do and who the kind of students we can pull to get you connected with some persons in Lagos. The opportunity is open. So much you can do. So much you can do.
In fact, Natalia is in Lagos.
Beautiful.
Eunice used to be in Lagos. So just reach out and then you'll be connected to all of them, you know. Make sure that some of these postings we send on the platform, share it on your social media handles, tag your mentors and your co-mentees where necessary, tag JIIPCC, tag Settlement House ADR Training Institute, and then to add, you know, Settlement House ADR Training Institute does its training and certification in all ADR mechanisms. So aside from the fact that some of us are born mediators or we are ADR practitioners by nature or we are peacemakers, sometimes if you are going to a formal institution, you may want to show them that, okay, I have a certificate, I've undergone training here and there, you know, that is evidence to show. So if you want to acquire that kind of thing, then eventually we are trying to work out modalities to see that some of the mentees who are interested in becoming certified mediators or arbitrators or whatsoever will be able to, through this mentorship, if you are successful, you will have a very discounted opportunity to undergo a certification training. You know, so we are still working on the modalities. Once we are able to conclude that, we'll reach out to you. So having said so, Mr. Dennis, your people have held us captive.
Yes, thank you so much, sir, and thank you to our mentees for asking your questions. It has been really been an interactive and an engaging session, and I believe everyone has learned a thing or two, especially on the side of our mentees. Right, our mentors have given us advices on how to go about the process of being mediators, and not just being mediators, or on how to excel in that particular field. So with that, we've come to the end of today's session, right? I want to thank our mentors, Mr. Nyacham, Miss Natalia, Miss Eunice, Miss Mariam. I can see our other mentors, Mr. Samuel. Thank you all for being on call today. Thank you for sparing your time and your knowledge to help us run through today's topic, mediation and career opportunities. I want to say a big thank you to all mentees also on call. Please, I advise that, like our mentors have earlier said, put out your content on LinkedIn, tag JIIPCC, tag Settlement House Training Institute, ADR Training Institute, tag our mentors. Make sure that you are publicizing the good news of ADR, and also putting yourself out there. And I want to say good night to everyone. And how
yes,
do all
Mr. Dennis, before they all go, please try and send the scenario we are going to be using ahead of time. You know, so that encourage them to begin to read up the scenario. We'll use it both for mediation practicals and mediation arbitration practical. So next week we are going to be discussing arbitration and career opportunities in arbitration. So please send the scenario so that they can begin to make use of it and read it and understand it before we get to that. And please post on your LinkedIn what you are learning is very important. Just as we said, that is the way you get to make other people know that you are doing something in ADR. Gradually, before you know it, you need people to get to know that you are into something before they can begin to look for you or ask you. Feel free to reach out to any one of us anytime, any day, you know, if you have further concern or questions. Thank you very much. Mr. Samuel, is there anything?
From my end, I just need to appreciate all the mentees and all the highly revered mentors for spending this time in impacting this young generation. Thank you so much. Thank you so much.
Thank you very much, Eunice, for joining us all the way from, she had to step out and come back. We are very happy. We are grateful. Thank you, Natalia. Thank you, Mariam. Thank you, Baratu. Thank you. Okay, Baratu. Baratu, is she still with us? Okay. We have already said goodbye. So see you next time on next week, Wednesday, and have a wonderful day ahead.
Thank you, everyone, for joining. Thank you, Nachan. And thank you, Samuel. And my
Thank
friend.
you.
Thank you, everyone.
Thank you, everyone. Nice meeting you all.
Bye. Yeah.